Okay, hi and welcome and thank you for joining us today to explore health and safety at work. What does it mean for me? My name is Amy Towers and I manage a risk management practice specialising in health and safety at work. I'm a consultant who is obsessed with setting you free when it comes to your work health and safety obligations. I've been working in health and safety for the past 16 years now, and I'm still uber passionate about the work that I do. I really enjoy solving complex business problems and truly passionate about guiding, directing and protecting people and their business against health and safety risks. Today we're going to unearth the focal points of the new health and safety at work laws in New Zealand. We're not going to get bogged down in the nitty-gritty of the regulations. Obviously, we'd need a lot more time than an hour to get through those points. So today what we'll do, we'll just ease our way into the main changes and highlight the most important elements that you need to be aware of and hone in on. Essentially, what I'd like to achieve today is to hand over the knowledge on this very important topic, to offer you my spin on things, and to hopefully offer you some food for thought in which you can filter and do some great things with. Always, if we have an opportunity at the end of the session, we can answer some questions. You have the opportunity to type into the chat section. Alternatively, you're always welcome to contact me and discuss things further if you wish. So today we're going to address a number of key topics. First, I wanted to give you some insight into the introduction of the health and safety at work laws, and then we'll work our way through what those key elements are, what of those key elements might catch you by surprise, what are those things that you need to hone in on, so those elements that require your attention straight up, and also let's take some learnings from Australia. These laws have been in play since 2012 in most of the jurisdictions in Australia. So we're now getting to see some case law come out of that, and that's really helpful for New Zealanders to really get a feel and an understanding of how that law plays out and how to tackle those new laws head on in New Zealand. So, as you are aware, the 4th of April 2016 was, I would say, a bit of a frightening date for many New Zealand businesses. It was like a dark cloud loomed and cast a shadow over business owners because there was something new coming along, some more compliance, more red tape. What does it all mean? So while businesses in New Zealand were geeing up for these new impending laws, we found that they were eagerly searching for answers of what it might look like, what was coming, what impact would these laws have on their business. And when I compare that search from New Zealand businesses, it wasn't too different to the reaction that Australians had back in 2012 when very similar laws were introduced. Obviously, when a change occurs, such as these laws, where there's significant alterations in terminology and understanding of what is required, it's going to bring about questions. So of course, businesses are concerned about the unknown, and we found that there were some really common questions being thrown at us. What is a PCBU? Who is an officer? What is due diligence? What is the likely penalty of a breach of duty of care? What do I need to do as an officer to avoid personal liability and going to jail? And what does the business as a PCBU need to do in addition to what is already in place? So again, all really relevant questions and the right questions to be asking. So that's what I really wanted to focus in on today, those common questions that surround these new laws. It also doesn't help New Zealand businesses when there was a heightened fear due to certain people who were, I guess, going about and informing businesses about significant changes of the laws, which there are, but it was a bit of scaremongering. And I actually read an article by Radio New Zealand. It was actually titled Scaremongering over New Zealand Regulations, and that date was 15th of January 2016, which said that Secondary School Principals Association reported that schools had been inundated with calls from consultants over the previous months telling them that they could, quote, go to jail when the Health and Safety at Work Act kicked in on April 4, 2016. So a bit of a frightening tactic. So while the issue raised by the consultants is technically true, so these laws do introduce penalties which are quite significant and carry potentially a jail term, the likelihood that the regulator, so WorkSafe New Zealand, was actually going to target officers as soon as that date hit, prosecute them and put them in jail was very unlikely. Gordon MacDonald, WorkSafe New Zealand's chief executive, actually had a response to the scaremongering. His statement around the scaremongering was, our position is that if people are doing the right thing now by the existing law, the changes they need to make to cope with the new law are probably not that significant. But if people aren't complying with the new law, then this is a wake-up call for them. So I guess that puts at ease some of the fears around the introduction of those new laws that clicked over on the 4th of April 2016. Unfortunately, in my experience, there are not too many organisations that I've worked with, that I've come across, that are on top of their obligations. So if you are on top of your obligations already, there shouldn't be too much more that you need to be doing to comply with the new laws. However, if you're aware that there are some significant gaps in any part of your health and safety management system, then it's really an opportunity for you to bulk that up. Make sure that you're managing it to the best of your ability, to the best of what is expected, and to ensure the health and safety of your workforce. So we could get carried away with all the changes of the Health and Safety at Work Act that it has brought about, but we don't need to. So why, you might ask, why don't we cover absolutely everything? My belief is that there are significant changes, and these significant changes, if you can't get those bits right, then you're really going to struggle with tackling all the other compliance requirements that are set out in the regulations. So let's focus on the Act. Let's focus on what those key changes are. Make sure you've got a good knowledge and understanding of them, and have a bit of a plan to tackle those things. So we've only got an hour here today, so let's use that wisely and focus in on what are those key components of the Health and Safety at Work Act that are going to impact you, your business and your workers. So I've highlighted what I feel are the key elements of the new laws, those ones that bring about the biggest change or awareness to businesses. So those are officers, and due diligence, PCBU, which is a person conducting a business or undertaking, and their duty to have a primary duty of care. Organisations or situations that involve multiple duty holders, and what I call the 3 Cs, which are consultation, cooperation and coordination. Workers, so what does that term include? Who does it refer to? Who owes that duty? And what are the penalties if something does go wrong, if you don't meet your obligations under the Health and Safety at Work Act? So we'll be touching on each of these throughout the presentation today. So what I wanted to focus on now is just really think about what are some of those key elements that might catch you by surprise. Which ones will shock you a little bit in the sense that you might feel a little overwhelmed about, wow, we have this duty, how we're going to tackle this. Now, I just want to give you a tip. If you, throughout this process, and it's not just today, the information that you're getting today, but ongoing, if you're feeling quite overwhelmed with, oh my goodness, we need to do this, we need to do this, we need to do this, it's not possible to have it all done overnight. Okay, and I don't think that you're expected to. So I encourage you to think about, okay, what's our strategy? It's like putting a budget together. Say if you wanted to save for a house. You want to be able to have a plan on how you're going to manage that and end up with the result that you want to in the end. So it might be a year that you're going to save for. It might be 2 years. It could be 3 years. It's the same approach applies for health and safety at work. You identify what you need to do to meet due diligence, to meet primary duty of care, and you put that in a plan and you put time frames to it and you work towards those goals. So just keep that in the back of your mind as we work through each of the points. So surprise, surprise, this is one of the ones that I feel most people get a bit uptight about. They're a bit unsure, it makes them feel a bit queasy, and I completely understand why. So the most common question about this term officer that I've experienced over the last few years is, how do I know if I'm an officer? Why am I an officer once they find out that they are? What do I have to do to meet my due diligence obligations? Can I choose to be an officer? And how do I opt out because I really don't like the look of what's required here, and I don't like the penalties that are associated with being an officer if due diligence isn't met. Okay, so officers and due diligence. So who is an officer? Basically, if you're a director of an organisation or a business, you are an officer. If you are a partner in a partnership, then you are an officer. If you hold a position in a body corporate or unincorporated body other than a company, a partnership or limited partnership, that is, so these are the key words here, that is comparable with that of a director of a company, then you are an officer. If you hold a position in a business or undertaking that allows you to exercise significant influence over the management of the business and undertaking, you are an officer. So I'm just going to repeat that again because this is really important. If you are a director of a business, if you're a partner within a business, if you hold a position that's comparable to that of a director of a company within a body corporate or unincorporated body, then you're an officer. If you're none of those things, however, you hold a position within a business or undertaking that allows you to exercise significant influence over the management of that business or undertaking, you are an officer. So significant influence. You have the ability to exercise significant influence over the management of a business. So that's the key there. The other ones are pretty straightforward. Director, yes, that's very clear. A partner, very clear. Someone who holds a very similar role to a director of a company, very clear. But the one that gets people is, what about this one that says whether or not I exercise significant influence over management? So who determines that? So basically the law does. So it's with case law that we get an understanding of who holds that duty. We've had one case in Australia where that's actually been tackled and determined, so we're going to have a look at that shortly. So my advice, as always, with this one is, if in doubt, so if you think you could be borderline, you're cusping that ability to exercise significant influence over management within your business, then assume the responsibility. You know that saying, it's better to be safe than sorry? Well, with the penalties that are associated with failure to demonstrate due diligence, you definitely don't want to be on the sorry side of this one. So there's no harm in assuming that you may be deemed an officer if you're really not sure whether you would fit in or outside of that definition. Assume that responsibility. So I can hear you already asking, well, what are the penalties if I am an officer that holds due diligence obligations and I don't meet these obligations? What am I looking at? So the maximum, so again, no scaremongering here. This is just purely what the Act identifies, which is a maximum penalty of an officer, $600,000 and or 5 years in prison. Now look, that is for reckless conduct. That's going out of your way, knowingly putting someone in a situation that's going to cause serious harm or fatality. An example would be instructing a truck driver to go and operate a vehicle that you know the brakes aren't working. That is reckless conduct. So of course that's going to hold a significant maximum penalty. Now we know that the maximum penalty is not in most cases reached. It's $300,000 for failure to comply with the duty that exposes an individual to a risk of serious injury. Again, that's just another category. So if you fail to meet your due diligence, but it wasn't reckless, maximum fine of $300,000. And another category for a failure to comply with the duty that didn't expose a person to a serious injury or illness or death is $100,000 maximum. The other thing I wanted to point out here is that you may not be the only officer within your business. So going through that process just now, you've said, okay, well, I'm a director, I'm definitely an officer. It doesn't mean that you're the only one that holds that role, who holds that obligation. However, you are responsible for meeting your own due diligence obligations. So within an organisation, there might be 5 or 6 people who are deemed officers as per that definition we just went through, and each of those people must exercise their due diligence. So it's an individual duty. Each person needs to exercise their due diligence. So due diligence isn't about attending a one-day training course to understand the health and safety at work laws, nor is it about having someone come in and audit your safety systems. So I think it's really important to understand that it's not a quick fix. It's not about doing a quick training course or having someone come in one day and just say, this is what you need to do. It's not about that. It's about understanding what your obligations are. It's about that strategic planning and making sure you've got the resources to support that process, and it's ongoing monitoring. It's like when you commit to a diet. I'm going on a diet, or I'm going to get really healthy, I'm going to go for a run every day, and a lot of people give up on their intentions. This is like that. It's a forever diet, basically. It's a forever healthy and exercise plan. It needs to happen every day. It needs to be churning away in the background. So in a nutshell, due diligence is about being well informed and prudent. So if a PCBU, so we'll get to that, what that is, but basically I'm going to say business for now. So if a business has the obligation to provide a primary duty of care to the workforce, as an officer of that company, they must exercise due diligence to ensure that the business complies with that primary duty of care. So just think about it as the officers, for example, the Prime Minister, and the business is Australia. So the Prime Minister is responsible for all the things that happen within Australia, in a sense. I'm really trying to make it simple here. So the officer is responsible for what the company does and doesn't have in place, and can be held accountable if the company is not providing a primary duty of care. Maybe a little bit different to the Prime Minister analogy, because they're not probably held accountable as much as they should be for certain things that happen. Okay. So an officer of a PCBU, so an officer of the business, must exercise the care, the diligence, and the skill. So care, diligence, skill, they're the key words that are actually, that's what's stated in the legislation, that a reasonable officer would exercise in the same circumstances, taking into account the nature of the business, the position of the officer, and the nature of the responsibilities undertaken by the officer. So what a reasonable officer would do in that situation. Again, open for interpretation, and we learn what that is through case law. And with also the regulator's guidance as well is also super helpful. So if we think about the definition of what due diligence is, it requires an officer to take reasonable steps. And that doesn't mean once an incident happens, the officer runs about and tries to get everything right. It's about the steps that happen before anything happens. It's about acquiring and keeping up to date with work health and safety matters. So what's going on in my business? What's going on out there? What are my workers exposed to? Understanding the operations of the business. So what are all of the functions of our business? Generally, what are the hazards and the risks that are associated with each part of that? I'm not sure if you've seen a show called Undercover Boss, but this is a perfect example of what's expected of a boss, of an officer. So as an officer, you're the undercover boss. You don't have to be undercover, but that process that undercover boss goes through, that they go out and they visit different areas within their business, really try and get an understanding of what the role involves, what the person is exposed to. Basically, they're putting themselves in their workers' shoes. And it's not until that moment that they really start discovering what some of the significant issues are. So that is part of due diligence. You're expected to understand the operations, each area, what are generally the hazards and risks that the workers are exposed to. And it's not just workers as well, but it could be the public. So what operational activities does your business do that expose other people outside of the organisation to those risks? You need to make sure as an officer that the business has available for use resources, and they need to be appropriate, and the processes to be able to manage those risks. Okay, so when I talk about manage, it doesn't mean get rid of all of them, although that would be great. It means tackling them. And when I say tackling them, I mean, how are you going to approach each one? Because each one's going to be different. Some you might be able to eliminate, others you might not. So what's your approach for tackling those risks? Ensure that the PCBU has the business has appropriate processes for receiving and considering information regarding incidents, hazards, risks, and also responding in a timely way. As an officer, is there a feedback flow of information related to health and safety at work? Is there incidents getting reported through to you? Are you aware of all the incidents that are happening, the types of hazards that are being reported, and then the information going out about what you're doing about those things? You also need to ensure that the business has and implements processes for complying with the obligation. So what structures do you have set up within your business to ensure that all of your obligations are identified? So for example, do you have a legal register? Do you know what parts of the Act and the regulations apply to your business? Do you have processes that are set up around those? Do you have training? Do you have auditing? Do you have worksite inspections to ensure that all of those things are being implemented and monitored? And the very last point on the due diligence obligation is, how do you verify the provision and the use of resources and processes that we've just talked about? So how do you verify that those things happen? It's all well and good to have a verbal system in place. Oh, that's just how we do things around here. Everyone knows that. It's common sense. Where's your documented system? How do I know that Joe Bloggs has had training in working at heights? If it's not written down, if it's not recorded, then I don't know that it's happened. There's no evidence there. So if you're an officer, just take a moment to identify where you think you might be on this quadrant that's up on the screen. Think about the actions that you must take to nail their diligent hotspot. So obviously you want to be here in the top right-hand quadrant. You need to be well informed about your business operations, the hazards, what legislation applies to your business. And you need to be prudent, that planning, asking questions all the time. Don't become complacent. That's what diligence is all about. Now, if you're down here on the right-hand side or the left or even at the top, think about, list what steps you need to take to get to that diligence hotspot. So I feel like we've covered officers, you know, it gives you enough food for thought to just process that and think about what you might need to be doing if you are an officer or if you work closely with an officer about what they might need to be doing to get kick-started on their due diligence obligations. Now we're going to have a look at PCBUs. This one's a little bit confusing for some people. Just it's the term I feel that confuses people. So this terminology replaces any previous reference to employer. It broadens the territory of who is a business or undertaking who owes a duty. It removes any discrepancies about who a business owes a duty to. And basically, you cannot say that because you don't pay a worker directly that they're not your worker. So what this term is trying to do, it's in trying to encapsulate workers paid or not, whether you directly hire them or indirectly influence, direct them. If they work for you for the business in any capacity, or if you're instructing that person to do certain activities for the business, then you are the PCBU, you're the person who conducts the business or undertaking, and those people are your workers. So again, the common questions that are thrown around with this one: is the director a PCBU? Who is the PCBU if there are multiple parties to an arrangement? For example, construction. Can I transfer my PCBU duties via a contract? What's the difference between a PCBU and an officer? So let's just think about the PCBU as a company, okay? So it's a business or undertaking. So it's not, essentially, don't think of it as a person at this point. So think of it, so PCBU is our business, it's our company. The officer is the individual that's responsible for the company, which is the PCBU. So the only time a director would be a PCBU is if they're a sole trader. So a person is only a PCBU if they're an individual. So for example, an independent contractor, I'm a sole trader, I run my own business and I contract to other organisations. So they are a PCBU, okay? But essentially it's the company. If there are multiple parties to an arrangement, for example, construction or labour hire is a really great example where you've got lots of different companies involved, businesses and undertakings, then each party to that arrangement are a PCBU. So you could have 100 on a construction site that are a PCBU or more. So each are a company and each hold the PCBU status. Each company is a person conducting a business or undertaking, and they hold a primary duty of care. So as a company, you are not able to contract out of your PCBU duties, which is a primary duty of care. You cannot put in a contract that you transfer all of your primary duty of care to health and safety at work to your principal contractor or to your subcontractor. You just can't do that. Even though you might like to try it, it doesn't work. So the difference between the PCBU and the officer, just to explain it again, is the PCBU is the company, unless they're a sole trader, but essentially the company, and the officer is the individual that's responsible for ensuring that the PCBU, the company, is meeting its primary duty of care. So as a business or undertaking, what is required to meet the primary duty of care? Without getting bogged down in this one, I just really wanted to express that the primary duty of care is a positive duty. So what we mean by a positive duty is that it needs to be proactive. Again, you can't wait until an incident happens and then run around and try and fix that and say, well, we've met our primary duty of care, we've sorted it out. That's not what it's about. It's about putting processes and structures in place to prevent incidents from happening, managing hazards before they arise or when they arise. So that includes things like ensuring a safe work environment, making sure that plant and structures are maintained, ensuring the provision and maintenance of safe systems of work. So when we talk about systems of work, is what are the policies and procedures that surround that particular activity to ensure that it's being done in the safest way possible. So also the safe use, handling, storage of plants, substances and structures. How do we know that what we're bringing into the organisation or into the business to clean, say, equipment is safe for our workers to use and handle, and that the storage of it is compatible with the other products that we've got here. These are all the things that you need to keep abreast of. Are we providing adequate facilities here? Do we provide first aid? Have we got emergency response plans in place? What information, instruction, training and supervision do we have in place to support all of the previous stuff that we've just mentioned? And what are the workplace conditions like? How are we checking those on an ongoing basis? All these things need to obviously be running like clockwork. Okay, let's now turn our attention to multiple PCBUs. So I mentioned at the start that this was a significant change, and it's really not a difficult one to get your head around. I've just used an example here of labour hire, or you might want to call it on hire. I like to call it on hire. So using temporary staff within your business. So the new laws are quite nifty in that they recognise that today's workplaces are not straightforward. It recognises that sometimes business arrangements are complex. And so let me explain this one a little bit. So assume you're an organisation that's coming up to a busy period. You need temporary staff to meet demand. You approach a labour hire or a temporary hire firm. You sign a contract with them to engage some workers over that period of time. Say you get 10 temporary workers from them. Sometimes the on-hire firm may not be able to fill those 10 positions, but they've committed to it. So then they go and engage workers from another on-hire firm. So that basically they're borrowing those on-hire workers, and they supply them to you under their umbrella. So that worker may be an independent contractor contracting through that on-hire firm. So what I've got here, you can see right at the bottom is, this is one of your temps that you want to engage. So essentially this independent contractor is coming all the way up to your business. However, there's a few other parties that are involved in this process. So the independent contractor to get to you to help you out with your busy period, say for the next 3 months, that independent contractor signed up to a payroll firm who's going to pay them. Then they've approached on-hire firm number 2 and said, I'm looking for work, but you place me and my payroll firm will pay me. Okay, so independent contractor is a PCBU. He's got his own business, he's operating as a sole trader, and so he's a PCBU. Payroll firm as a business who's in some way engaging the independent contractor by payment is also a PCBU. The on-hire firm that's now going to place independent contractor with the other on-hire firm, so they're saying, here you can borrow independent contractor for the next 3 months. And then on-hire firm number 1 supplies that independent contractor to your business. So you can see the different PCBUs that are involved in just that one placement. So down the side there, I've identified each one as a PCBU. So each one is a business. Each one has an obligation to that independent contractor because they are the PCBU that's involved in the arrangement, the placement of work for that worker. So your business is a PCBU and the independent contractor will be your worker for the 3 months. On hire firm number 1 is placing that worker, that independent contractor, so that's their worker. Same with the other 2. But what do each party need to do to meet their primary duty of care to that independent contractor whilst on placement? Who is responsible? So who is the duty of care owed to? It is the independent contractor, so let's focus on that. So we need to ensure that the health and safety of the independent contractor is covered whilst they're on placement for those 3 months. So each PCBU needs to carry out their primary duty of care. They can't transfer it to any other party. Each party owes that duty. So they need to demonstrate that they're each doing their own thing to ensure the safety of the independent contractor. Now, how much influence and direction each PCBU has over that independent contractor will determine to what extent they need to go to ensure the health and safety of that contractor. Okay. So as a PCBU, your business, who do you owe duties to? So I just provide an example there where there's multiple parties involved. But as a business, this one's an IOU. I owe you a duty. But who do you owe that duty to? So part of due diligence for an officer is understanding your workforce. And again, it's not just the workers that you directly engage that you're responsible for. So the new laws don't direct the duty of care to those that you directly engage. So guess who else might be owed a duty? A PCBU, so your business, must ensure the health and safety of workers who work for the business while the workers are at work within the business, and workers whose activities in carrying out work are influenced or directed by the PCBU while the workers are carrying out their work. So I'm just going to jump to the next slide for a second, just so you can get a sense of who might be deemed, other than your direct employees, who might be deemed a worker under your PCBU structure. So we've got students on placement, volunteers, we explain the on-hire worker situation, an employee of a contractor or subcontractor, and obviously the contractors and subcontractors that you engage. So if they're doing any work for you in whatever capacity, paid or not, directly through your organisation or not, they are deemed your worker and you owe them a primary duty of care. So let me give you an example on this one. Let's take a large department store, say David Jones. I understand David Jones is now in New Zealand. Within that you have concession stores. So I was actually a couple of years ago working with a retailer that had a concession store within a large department store. So just assume a David Jones type situation. This concession store, so a small little brand, like a boutique brand, that's operating their own small section within the larger department store. So separate businesses just using the space and obviously, you know, maximising on a large department store's customers that are coming in. So they had their own staff, so this is the concession store, they had their own staff, they had their own counter within the large department store. The customers who were buying their items would go into their section and engage with their workers. However, they shared a storage room. They were expected to help out the large department store when the department store got busy. So they were asked, could you serve our customers? And they would step in. Sometimes they were asked by staff of the department store to help bring stock up from the storage area. And they were able to use the department store's equipment, such as trolleys, to bring their own stock up. So whilst the large department store was not their direct employer, the concession store workers' direct employer, but the department store were directing and influencing the concession store workers. So the concession store were under their own company, but working within a larger department store because they were stepping in and being asked to help serve, because they were asked to go down to the loading bay and help with the delivery or bring up stock for the large department store, they were being directed and influenced by that department store that was not their employer. Therefore, that large department store, whilst not paying the concession workers themselves, were a PCBU and owed those workers a primary duty of care. Therefore, if an incident were to occur under these arrangements, just have a think about the PCBU who would be responsible for that worker. So in that case, it would be both the concession store as a business and also the large department store, because they were the ones that were directing and influencing the worker. So another example of multiple duty holders. So just a question here for you to consider. Have you identified all of your workers, and do your systems ensure that they apply to each type of worker that you engage, direct or influence? Okay, so I've given you some insight into, again, what I feel are the key elements of the new health and safety at work laws, which are officers, so who they are, what due diligence is, also what a PCBU is, how that is different from an officer, multiple duty holders, and the duty to consult, cooperate and coordinate, so that's work together to resolve issues, and also who is a worker and who owes the duty to the worker. So the question is, if an officer doesn't meet their due diligence obligations, if the PCBU as a business or undertaking doesn't meet their primary duty of care, so if it all goes pear-shaped, what happens? So if you have strategic planning, world-class health and safety management systems, you're not going to get to this. However, if you don't, these are the potential penalties that you could be facing. So I've already mentioned the officers one, but let's have a think about the PCBU. So as a business, if you fail to meet your primary duty of care, then there's a maximum fine of $3 million. Again, maximum, that is for reckless conduct. So reckless conduct in respect to the duty that exposes an individual to a risk of serious injury, serious illness or death. 1.5 million maximum for failure to comply with a duty that exposes an individual that's not a reckless incident, and $500,000 maximum fine for failure to comply with a duty that doesn't expose someone to a serious injury, illness or death. Now, other than the officer and the PCBU, there are other people within the workplace that can be held accountable for breaches of their duty. So, for example, a worker. If a worker is involved in a practical joke, and it's happened before, unfortunately, many times where, you know, they may have set someone on fire or, you know, just been involved in horseplay, then they're failing to meet their duty of care, and they could be potentially be exposed to significant penalties as well. And that includes prison and significant fines associated with that as well. There are also alternatives to monetary fines. So that might be an adverse publicity order, so you might need to put in your annual report that you subjected a worker to an unsafe work environment which resulted in amputation or whatever it might be. You might have an opportunity to put those funds into an improvement program. So we're now going to focus on maintaining our plant and ensuring that we have plant hazard identification being done to prevent amputation from happening again, and that money is then put into that rather than paying a monetary fine. So honing in, what are the elements that require your attention straight up? So it's the who, what, when and how. So there's no doubt about it. You need to start at the top, as this is where the ultimate duty lies, is with the officer. The culture and the climate need to be right within the business. The aim is to evolve through the evolutionary mode of safety culture. So again, if you're going to start anywhere, start with the understanding at the top management, because it can be really difficult if you start, you know, midway within the organisation and try and push up and down. The officers need to know who they are. They need to understand what their obligations are. They need to know what their risks are, and they need to check whether their PCBU is all sorted when it comes to primary duty of care. So that's where I think attention should be focused on. So how does this actually translate into practice? So get your senior management team together, work out who the officers are by applying the definition, get some education, a session to understand what due diligence is, workshop ideas on strategy by engaging the workforce, do a bit of an undercover boss scenario, develop that strategy, forever work on it. Like I said, it's like the forever diet or healthy eating plan. It needs to be continuous. Prepare due diligence plans like you would a business plan, and I mentioned that at the start. Develop and implement clear and concise senior management reporting processes so you've got that feedback happening. Audit your safety management system against the new requirements. Where are you at? Where are the gaps? And develop your implementation plan, identifying safety objectives and targets, and allocate responsibility to those things. Upgrade your system based on your findings of where the gaps are and following your implementation plan. And importantly, educate and engage with your staff. Obviously, you can't tackle it all at once, and that's what I expressed at the start of the webinar. So prioritise. What is glaringly obvious? What needs attention first? This will be driven by, firstly, the audit, where you measure up against the new requirements or the requirements, and your plan that you've prepared. So this is Hudson's evolutionary model of safety culture. You don't want to be hanging around the pathological reactive area or even calculative. You want to be up near proactive and generative. Sorry. So that is world class, the top one. Safety is how we do business around here. It's not treated as this is how we do safety and it's separate to how we do business. It's embedded within business process. That's where you want to be at. Okay. So just take a moment, consider where your organisation is at. Pinpoint it. You need to aim to get to the proactive and to the generative stages of the safety culture. It's definitely not an overnighter. Okay. just a couple of learnings from some case law in Australia that I'm going to share with you. Okay. The first one was a really public case that was in the media because it was one of the more significant ones that let us understand a bit more about officers and due diligence under, in Australia we call it work health and safety laws, but same as the health and safety at work laws. So Kainos Contractors, it was a test of who is an officer. So the case was brought before the Australian Capital Territory Industrial Court, involving a prosecution against an alleged officer of a PCBU for failing to exercise due diligence. Chief Industrial Magistrate Lorraine Walker published her reasons for dismissing the charge against Mr. Al-Hassani, who was the officer that was facing prosecution. So he was up for prosecution, but those charges were dismissed. So the main facts in the case were, on the 23rd of March 2012, Michael Booth, a driver employed by a contractor engaged by Kainos Contractors to deliver materials for the project, was fatally electrocuted when the bucket of his truck came close to or contacted overhead power lines at the site. Kainos Contractors' corporate structure was not fully described, but appears to have comprised a number of senior roles, including a director, general manager, and he was also the safety officer for the business. Mr. Al-Hassani was described as the project manager and was responsible for managing all major projects for Kainos Contractors. The organisational chart of the project noted Mr. Al-Hassani at the head with the safety officer below him. The project engineer, surveyor and general foreman also appeared as direct reports to Mr. Al-Hassani. Mr. Al-Hassani said he reported to the general manager and the company director, and that in terms of his scope of decision-making power, the general manager was El Supremo. There were other people in the accounting and admin departments between him and the general manager and the company director. He could not direct payments to be made to any party or employ people to purchase basic consumables. He prepared tenders but proposed prices he had to be approved by management. He performed traditional project manager responsibilities. So basically what he's saying is, yes, I was the project manager and I held manager duties. However, I was not ultimately responsible for payments, for making decisions for the whole of the organisation. There were people in between me and people at a higher level that made those decisions. So again, his defence was that he didn't have the ability to exercise power over the whole organisation. The learned magistrate concluded that notwithstanding Mr. Al-Hassani's role as a project manager, the prosecution had not proven that he did in fact make decisions or participate in decisions that affected either the whole or substantial part of Kainos Contractors' business. So that was a really significant case in work health and safety law in Australia, and it just gives you a bit of a sense of what might be considered when determining that last part that we went through around the definition of who is an officer, around exercising power to make decisions. The last one that I wanted to share with you was a very recent one that involved a training apprentice service. So a recent conviction in the industrial court resulted in a $14,000 fine to a trainee and apprentice placement service. It should remind all training organisations that they have a shared work health and safety duty with host employers. So when I gave that example of the on-hire situation earlier, where you've got multiple duty holders, you all share that responsibility to that worker. So on the 15th of January 2014, apprentice Jack Reynolds was working on guttering under the guidance of Joseph Argent, trading as Shear Edge Roofing, a host employer for the group training organisation. Mr. Reynolds sustained multiple injuries when the gutter he was working on came into contact with his high voltage wires. Following an investigation by SafeWork South Australia, Trainee and Apprentice Placement Service was charged with offences under the Work Health and Safety Act for failing to consult with duty holders. So where you've got multiple duty holders, you have a duty to consult, cooperate and coordinate. So that is, if a problem comes up, if a hazard's identified, if there's any particular issues, you have a duty to work with the other PCBUs that are involved in that arrangement and coordinate who's going to do what. So there was a failure there. So with a possible $100,000 maximum penalty for a body corporate, the magistrate settled on an initial fine of $20,000 and then reduced it to $14,000 plus court costs in recognition that the service gave an early guilty plea. The magistrate stated that they were satisfied that the defendant acted swiftly, demonstrated by the compliance with improvement notices, and made every effort to improve its safety systems. They had a duty to protect the safety of their apprentice and shared that duty with the host employer. This case highlights the importance of training organisations consulting, cooperating and coordinating health and safety activities with the host employer. So that was a statement made by SafeWork South Australia's Executive Director, Miss Marie Boland. So this was a first case of a failure and a prosecution under what is our section 46, to consult, cooperate and coordinate. So again, another significant piece of case law under the new laws here. Again, food for thought for those in New Zealand who have the same duty there. Okay, so just to finish off, I wanted to just again summarise how you might tackle these new laws. So number one, super important, just to start the conversation. I know it might sound, like a really simple action, but it's actually the key to getting it right. If you can't get this right, being able to have a chat with your workforce, then the systems are really on the road to nowhere, because you're not going to be able to apply the safe systems of work with a workforce that's not engaged. So having conversations, getting the workers involved is critical in understanding what the risks are and how you can do something about them. My top 3 starters include open communication lines with your workers. How do you engage with them? Think about strategies to ensure there is a respected flow of information. Chat, listen, observe. Suss out what your operational risks are, jot them down. Carefully plan and strategically approach your risks from highest risk down. Work out what you want to achieve, how you're going to measure this, what resources are required, what's your timeline, and if you can't manage these things internally, reach out and get some help to work through this process. Okay, so I just wanted to take the opportunity to thank you all for your participation today in attending. And please, if you do have any questions following today's webinar, please reach out to me. I'd be more than happy to have a chat with you. So if you want to know more, we've got some links here within the presentation. So you can head on over to my webpage and join the fold. You can check out some recent blogs that address officer and PCBU duties and the need to have that open communication with your workforce. Inquire about the Undressing Risk program, which is a face-to-face, really interactive training session where we get to undress what the risks are within your business and how you might start to think about tackling those. And if you haven't already, connect with me on LinkedIn. I'd love to engage with you on there. Just so you know, we've recorded this webinar today, so you can have access to this, and you are more than welcome to share it with others if you think they would be of interest. So finally, thank you very much for participating today, and I hope to speak to you soon. Thank you.